discovery. This is the opportunity for you to learn about your case, to learn the strengths and weaknesses of your case. You do this through a number of pretrial processes. They can include such things as requests for interrogatories. Those are written legal questions. They can be gathered through requests for production. That is where you're asking for production of documents and things. You can ask for production of a computer. You can ask for inspection of a premises. In other words, production of the land, if you will. Inspection of an individual person, such as in a PI situation, personal injury, wrongful death, or where someone needs to be examined for some reason. There are requests for admissions, where you're asking an opposing party to admit something, to admit the validity of a document, to admit that they received something. And then you have depositions, which are live, written questions that you get to ask orally. You write down your questions, you bring them in, you orally ask them of the other witness, and they answer under oath. Let's talk about each of those categories. Interrogatories. Interrogatories are written questions that you send to the other side. It is your opportunity to ask questions to secure information. For example, please state all of the witnesses who have knowledge of the facts of this case. Or, please list all of the documents which are related in any way to the subject matter of this litigation. Please tell me the facts of the case that you believe support the allegations of your complaint. Please state the facts which you believe support your denials of the allegations in the complaint. These are ways to secure information from the other side. You send out the written piece of paper or papers to the other side, and those questions must be answered under oath. So they have to write down the answer, and they have to certify, get it sworn, that they are answering these questions under oath. Interrogatories are generally sent to parties, not to witnesses. They're sent to the plaintiff or the defendant or to the state, the government. This way, you can acquire information which may be useful in depositions or requests for production or other vehicles. It's a way of you gathering evidence to help your case. Requests for production. Requests for production are what they sound like. You are requesting the production of something. It is a written document whereby you request, please produce the entire copy of the contract, the entire copy of the insurance policy that you say is related to this action. Please provide the copy of the contract that you believe was executed that requires performance. Please provide all of the documents which you believe support your case. Please provide all of the documents which support your claim that there was a breach of contract. You can understand how what we're doing is we're requesting somebody to produce things. Now contrast that with the interrogatories, where you're asking questions and you're getting back information. In the interrogatory sense, it's a question. Please state all the facts. You're not gathering documents, you're gathering information. In the request for production, I'm actually asking them to produce that document. I'm asking them to allow me to inspect that land, inspect that computer, inspect that hard drive, to inspect that person. The production request allows you to gather actual tangible things, which can be used along with interrogatories. This is a neat and really cool way to gather specific documents that are related to the case. You can combine that, as we mentioned, with the interrogatory, so now you have answers to written questions under oath, and then you have somebody producing documents which are related to the facts of the case. Another method is requests for admissions. These are requests which enable you to limit or narrow issues. Please admit that this is your signature on the back of the copy of this check which I'm providing with this request. Maybe it's a case where I'm trying to prove that somebody cashed a check. Please confirm that this is your signature on the contract, because I'm trying to show that they actually signed the agreement. In those situations, I don't want to have to go to trial and spend lots of time debating about whether that's the person's actual signature, whether that is the actual document. I don't want to have to bring in a handwriting expert or to have to go through a bunch of foundational things, difficult obstacles, in order to prove something that we all agree is true. That's a great technique to use when you're doing things like requests for admissions. What are you trying to admit? You're trying to admit things which you think are not in controversy, or things which you want to limit down the issues so that we don't have any more to discuss than what is necessary for the trial. Depositions. Depositions are a vehicle by which you can question witnesses. Now, in depositions, the witness who is responding is under oath. So you're essentially securing a sworn statement. You're securing sworn testimony. And you have the liberty to ask questions that are related to your case or that may lead to evidence that's related to your case. So, I go to a deposition physically, or I attend by phone, or I attend by video, I attend remotely, and I get to ask questions of the other witness. This enables you to gather more information directly from the person. Let's say that I'm a plaintiff and I want to take the deposition of a defendant in a breach of contract case because I say that they breached the contract and they didn't pay the money they were supposed to pay. I take the deposition of the defendant and I ask him, "Sir or ma'am, do you see the contract that you executed?" "I do." "And does that provide that you must pay when we receive the material?" "Yes, it does." "Okay. Can you tell me what my client did for you?" "Well, your client delivered 5,000 wristbands. And were those wristbands the proper wristbands that you ordered?" "They were." "Okay. The contract says that you are to pay $2,000 for those wristbands. Did you in fact pay that $2,000? "I did not." Okay, what I've done is I have shown that the plaintiff has performed and I have shown that the defendant has not performed. This is just an example of how you can secure information in a sworn capacity. Now, stylistically, you may want to go about that questioning in a different way, depending upon the circumstances of the case. For example, generally speaking, you want to ask open-ended questions, different than the example I gave you. You want to ask questions that are like who, what, where, why. Please describe, when, how. Please explain. Please tell me all the information you have on X. The idea is to get the witness talking. Generally speaking, when you're taking depositions, more is more. I want to ask a question. I don't really know what the witness is going to be saying. But whatever they're saying, I want to go ahead and learn as much as I can from them. I want to exhaust, essentially taking like a piece of bounty paper and sucking up all of the information I can from that person. Most times you will not know all of the information that they have. And that is why it is so important that you ask questions that are open-ended and essentially get all of the information out of the person. Would you please tell me all the witnesses that saw the car going through the red light? Sure, Mr. Major. It was Tom Smith, it was Bob Smith, and it was Jim Smith. Now watch how I follow up. I don't know if that's all the people. So I say, you have told me that there is Tom Smith, Bob Smith, and Jim Smith. Is that all the people that you know that saw the car going through the intersection at a red light? Well, now that I think of it, Fred Smith was also there. See, what I've done is, instead of assuming that the person answered the question fully, I used an exhaustion technique, a technique of saying, am I sure that I have squeezed all of that information out of that person? Did they forget? Can I help them to recollect so that I make sure that I have all that information? Then I can use a repetition technique. Okay, thank you. So you've said Bob, Ted, Fred, Sam, all the names that they gave, however many they gave, are all the witnesses. Is there anybody else that you think could have saw a person standing or actually themselves saw the car going through the light when it turned red? I asked an exhaustion technique, but I added a little bit more. And I actually added something that said maybe they saw somebody who might have seen it. The person might say, well, there was actually a couple other people at the intersection, but I don't really know them. Do you see what I'm doing? I'm asking questions to gather more information. I'm asking questions to make sure that I understand everything the witness has said. So when I ask open-ended questions, it frames for me the information. I call it like shrimp netting. I'm going to go out and grab all the information I can. I'm going to throw a giant net out and grab all that information and make sure I have everything. Then I'll pick through the shrimp to see which lobsters I want to pull out. So essentially, this discovery technique, this deposition pattern, is a way of securing information. A deposition allows you to be more free. You can ask more questions. You can be more broad than you can, say, if you ask an interrogatory question where the person finitely asks or answers something, and then you really don't have any vehicle to re-ask them unless you send out yet another set of interrogatories. So the deposition allows you to have a fluid conversation to learn more. I want to make sure that I gather all the information that is related to that case, or all the witnesses that might know about the case, all the documents that might be related to the case, all the facts that might be related to the case. And I do that through the deposition. If I want documents, I might ask them, are you aware of any documents that support your case? Or said another way, please provide me, please tell me about all the documents that you believe support your case. Or if you want to use exhibits, you can actually take those documents, let's say you had them because you received them in a request for production, and you could have an exhibit and mark it. By marking it, you write the number down. It's plaintiff's exhibit number 1, or the court reporter will do it for you. And you say, I am referring to plaintiff's exhibit number 1. The reason why you do that is because you want the typing to pick up exactly what document you're referring to. If I just say something like, look at this document. Is that your signature on it? Right there? Yeah, right there. Are you sure? Yeah. Not this one, but that one. Right? Right. Try reading that. Try understanding what that says. So you have to be directional in a deposition. I am showing you what I've marked as plaintiff exhibit number 1. It is a photograph of all of the people that were standing at the intersection. Sir, would you take a look at that and tell me whether you identify that, whether you see that, whether you know that that is the picture? And presumably I would do this because let's say I got the picture from them. So that witness, that defendant might say, yes, that is the photograph that depicts all of the people that were standing there. So you see what I've done is I'm using a document and asking questions. I might say, are you aware, or please tell me if there are any other pictures that depict the intersection, or what other pictures were taken, or tell me about the other pictures that were taken. If I ask a question like that, that presumes for the witness that I'm assuming there's more than one picture. If I'm not sure and I ask that question, then that witness either has to tell me about those pictures or has to say, there are no more pictures. What I've done is I want to create a box. When I throw my net out, I want to make sure I catch all the shrimp. So I want to make sure when I ask that question, I don't find out later that there's actually 3 other pictures out there. They just didn't give them to me because somebody else took them. So you want to make sure that you don't make assumptions and that you capture all of that information before you move to another topic. If the person says, well, there's 5 of the pictures, but they were taken by Bob. Okay, where are those pictures? How do you know those pictures were taken by Bob? Have you seen those pictures? Please tell me what those pictures depict, or where are they located right now? I'm asking questions to gather information. You can see in the deposition process, I'm asking questions to discover facts. I'm also asking questions to discover witnesses. Each time I might ask a question, or I might reference a document, I might say, please tell me all of the persons, all of the entities, all of the witnesses that you believe have knowledge about the intersection, about the car entering the intersection, about the contract, about the failure to pay, whatever your line is. The person will answer. Use that exhaustion, that repetition technique that allows you to say, let me make sure I understand. You said Bob and Fred are 2 other people that might have knowledge. Anybody else? Or, besides Bob and Fred, who else knew about that contract? Saw that person run the red light? That's a presumptive thing. Then the witness has to either say, well, Jim did, or there are no other witnesses. That continuing exhaustion technique while you're gathering information is critical to good depositions. You're trying to learn what is the theory of the other person's case. What is their defense? What is their position? I make jokes that I say, I don't care what a witness says so long as he says it. You don't really care what they say most of the time because you're gathering information. What you want to know is what is their position so that then you can formulate your case around that. Maybe they're making false statements. Maybe they're making true statements. Maybe you don't know whether they're true or false. But you learn what their position is. Tell me why you think you should not have to pay for the wristbands. Well, because they were the wrong color or they were delivered 2 days late. Okay, you say that they were the wrong color. Aside from the wrong color, is there any other reason why you believe that you should not have to pay? You see that exhaustion, that boxing technique? If the person says, yeah, there's other reasons, I don't like the way he dressed. Whatever those answers are, you gather all that information. If they say, yes, that's the only reason, now I know that their position is that it was not provided to them in a timely way. And that is the sole basis for their defense of non-payment. So you can see how that enables you to now frame what the opposing's case is. You can also test theories. You can ask questions that relate to the facts of your case. You can say things like, are you convinced? Do you agree with me that all the goods were delivered? Or, how many goods were delivered on that date? Well, all 5,000. So if I understand your testimony correctly, you're saying that all of the wristbands were delivered. They just were delivered too late. Is that a fair representation? Absolutely, that's what I believe. I'm not complaining about the amount of wristbands that they were delivered. I'm complaining about when they were delivered. Okay, do you see how I'm framing that? The deposition allows you to go through and gather facts, to gather information about who the witnesses are, to frame out what the legal theories are, to understand or box or limit what the other side is saying. It also allows you to understand how good your case is, how strong your case is, where the strengths or weaknesses are, or what you're going to need in response. That is quintessential to the way you handle a deposition. In interrogatories, the types of questions that you ask are also important. I want to ask questions that will enable me to gather the most information. Understand, when I'm asking interrogatories, it is a finite question. Please state all of the witnesses that you believe were standing at the intersection when the car went through the light, when the car went through the red light, when the car went through what you say was the red light, whatever the case may be. It's only a question. I can't follow up right there. So I need to make sure I ask a question that gathers me the most information out of that question. Please state all facts which you believe justify why you don't have to pay for the wristbands, why you did not make payment for the 5,000 wristbands that were delivered on July 1st. I want to make sure I get all facts, not just some facts. Please state in extensive detail all of the facts. Please list all witnesses which will support that testimony. So, for example, please state all of the facts which justify why you should not have had to pay the $2,000 for the 5,000 wristbands that were delivered. Then I put underneath that, please state all the witnesses that will support those facts. Please state all the documents that will support that fact. Maybe they'll list an email. Maybe they'll list some other type of document. But the key is that I'm learning information. So interrogatories are very open-ended and designed to gather your information. What's critical about interrogatories is to understand that the question has to be broad enough to capture the information, but not so broad that you can't understand it or that it's confusing. So it's important when you write to write plainly, write simply, and if you think you're going to use a word, like let's say I'm using documents, please list all documents. So that there's no confusion, I want to have a definition section. A document includes, but is not limited to, correspondence, emails, letters, any handwritings, recorded events, blah, blah, blah. You can list those, and then if the witness wants to complain or wants to challenge it, they can go to that definition. They can't say, well, you didn't say it included emails. So you can have definitions to explain certain things so that you don't have to say, please provide or please list all emails, correspondence, handwritten notes on napkins, checks, payments, receipts. You can list that all in your definition section and then use the word documents. You want to make sure that your questions are related to what you're trying to prove. I want to learn about their side, what information they have, but I want to make sure that information is going to help me to understand whether my case is going to be successful. So the interrogatories allow you to gather information and also to learn about your case. Requests for production. As we discussed, requests for production are asking for physical documents. You want to ask for the documents which are related to the case. Please produce all contracts that you believe allow you to refuse to pay the amount of money that is owed in this litigation. Please provide an explanation or a list of documents or all of the documents that support your claim that the car that hit you ran a red light. Please provide all of the documents that support that you made payment of the amount of money that is required by the contract. You see what I'm doing? I'm asking them for physical documents. Please provide me with specific documents that are going to support either your case or going to end up proving mine. So production requests, I want to think through, what am I trying to get? Again, in these techniques, like interrogatories, like production, more is more. Because I don't know necessarily what they have. I want to make sure I get it all. So that discovery technique allows you to do that. Requests for admissions. Requests for admissions allow you to narrow the issues. They allow you to ask questions, written questions, which will tailor, narrow down, shape, get someone to admit a fact that you don't need to prove later. Question number 1. Please confirm, please admit that the document which is stapled to this request and marked as exhibit number 1 is a copy of your signature, is a copy of your check with your signature on it. See, instead of going through a handwriting expert and having to fight over this, what I can do is I can ask that question and they're likely to admit it, and then I can go right to the subject matter of the case, whether they paid or not, without having to go through the extraneous stuff that we both know should be omitted. So requests for admissions can allow you to narrow the focus of a case, to get things which you both concede out of the way. That's an important tool in requests for admissions. If a person denies a request, then it also allows you to see what you need to prove. That is not I deny that. It's my signature. Okay, well maybe they're making a claim that somebody else signed it for them. I learned that by their denial. I'm going to ask some questions perhaps in the deposition or in my discovery. Say my request for interrogatories, my set of interrogatories, my request for production, that's going to ask them, you denied that the document attached as Exhibit 1 was your signature. Please provide all facts which support that claim. You see what I've done? I'm using the discovery process to learn information. The request for admissions can be a useful tool in that regard. Requests for production, when it relates to documents, things, and people. A request for production can also include a request to inspect the premises. Say you have a storm case or a hurricane damage case where you're suing the insurance company because they're not paying for damage which a storm caused, which the insurance policy would normally cover. So you want to go out and inspect that roof. You can do a request for production to essentially produce the home, to allow you to inspect that home to see those damages. Sometimes in cases that involve people or their condition, a disability case, a case involving psychological harm, a case of personal injury case, sometimes you need to examine the person to establish whether or not their injury is as bad as it is, or maybe some other psychological things that you can't get across necessarily in a written request. So you want a doctor to examine them. You can do a request to examine the person. So you can see how you can use these tools to gather all of the evidence you're going to need to get ready for the trial. Discovery is a wonderful and necessary tool to succeed in any trial.